Over the last decade, inheritance disputes are being discussed more and more, whether that be a celebrity's estate or an eye-catching £1 million headline. But what are the different types of inheritance disputes, and how can WBW help navigate you through these disputes when they often come at such a difficult time? The umbrella term inheritance disputes, or contentious probates, covers various disputes that can arise after someone has passed away. There may be a challenge to the validity of the will itself. Perhaps there are concerns over the testator's capacity at the time that they signed their will, due to dementia or another cognitive issue. Or maybe there are concerns that they were forced to sign their will by a controlling family member or acquaintance. There are also instances whereby the valid execution of the will may be questioned. For example, was the will signed and witnessed by 2 independent witnesses? All of these disputes are challenges to the validity of the will itself. The other most common inheritance dispute is when someone feels that they haven't been adequately provided for in someone's will. This may be a total exclusion, but can also be a lesser than expected amount. Claims such as this fall under the Inheritance Provision for Family and Dependants Act 1975, otherwise known as the IPFDA or 1975 Act. For someone to bring a claim under the 1975 Act, they must fall into a certain category. These include, but are not limited to, a spouse of the deceased, a child of the deceased, someone who is living with the deceased for 2 years prior to the date of their death, or someone who is financially maintained by the deceased in some way. However, just because someone falls into one of these categories and has standing to bring a claim, that does not necessarily mean that they will be successful in that claim. When assessing the strength of someone's claim, there are a number of factors to consider, which include, but are not limited to, the financial circumstances of both the person bringing the claim and the beneficiaries affected by that claim. We must also consider whether the person bringing the claim or the beneficiaries again have any physical or mental disability, or whether the deceased had any ongoing obligations to the person bringing the claim or the beneficiaries. Other factors that are also considered in these claims are the size and nature of the estate, to ensure that the estate itself is not totally consumed in the course of litigation. The other thing that is also considered is the conduct of the parties, both the person bringing the claim, the beneficiaries who may be affected, but also the conduct of the deceased in their lifetime. These sorts of claims are not challenges against the will itself, but instead a claim against the estate, asking for provision on behalf of a disappointed beneficiary. Other disputes that we are also seeing more frequently are executor disputes, whereby a co-executor or beneficiary of an estate feel that the executor or executors are not acting in the best interests of the estate and the beneficiaries. The role of an executor is one of great responsibility and personal liability, so ensuring that the duties associated with this role are fulfilled is extremely important. Across inheritance disputes, however, there is one piece of advice that is applicable to all. Please seek legal advice as soon as possible if you think that you may be bringing or defending a claim such as these. Some of these claims have very strict timescales, and in all claims, ensuring that legal advice is sought as soon as possible before estate distributions have taken place will only increase the likelihood of success. As estate values rise with the increase in property prices, family structures changing, and many people living longer, inheritance disputes are only going to become more prevalent. If you have any questions about any of these matters or are concerned about your own estate when you pass away, please contact WBW's Contentious Probate team and we will be able to assist.